Alright, what are we talking about? Bullying.
Bullying. Which you'll be on the receiving end of if you don't.
Our area of expertise.
Indeed.
Alright, here we go.
Are you ready? Go for it.
Good evening.
Horror was the now's of Tom. Dum.
Welcome to Legal Beagles. I'm Cal, this is Al. Today we're talking about a topic that's near and dear to both of our hearts, and one which I'd say we're quite versed at.
Well, certainly. I as the victim, you as the deliverer.
We're of course talking about workplace bullying. This video will be admitted as Exhibit 1 in my unfair dismissal, my bullying claim in the Fair Work Commission.
Well, finally.
Now, Alex, workplace bullying it's in a bit of a funny spot at the moment, isn't it?
Well, this is one of those lovely areas where, when it happens, you can go any number of ways with it. Now, obviously, as you alluded to earlier, the first port of call, or certainly the easiest and cheapest port of call to get to,
and has been the only port of call pretty much up until this point,
is the Fair Work Commission's anti-bullying jurisdiction. Not often used, relatively speaking. There's only around about 700 or so applications to it each year, fairly consistently, since it came in a few years ago.
Yep, that's right.
Of those cases, probably about 10% of them, or 70, get a final determination.
Although it should be, one thing that isn't recorded in the stats though is that quite a lot are resolved privately of those 700. Yeah. So it's not like the other 90% are wasted.
But also what isn't shown in the stats is that of that 10% that are resolved by a final order, the overwhelming majority of those final orders are the Commission no longer has the jurisdiction to hear the matter.
Yeah, that's also true. So essentially, there's three, if an employee has an issue with workplace bullying, there's essentially, depending on what it is, what constitutes bullying, there's essentially 3 different avenues you can go down.
Or 4, depending on how you count them.
Well, that's what I said. It depends on what constitutes workplace bullying. You've got the Fair Work Commission, which has historically been the anti-bullying jurisdiction, right? Problem with the Fair Work Commission's jurisdiction is that can only make orders while someone's still employed. So as Alex has alluded to, a lot of the cases that are decided because someone's no longer employed. So even if there was bullying, Commission can't do anything about it. Commission also can't make orders with respect to compensation. All the Fair Work Commission can do is say, you stop bullying you, and they can have certain powers with respect to mechanisms like changing reporting lines and that sort of thing to give effect to that order. But up until now, no money involved, literally just a stop bullying order, which is why it's called the stop bullying order.
Yes, well, rather amusing that. The clue is rather in the name.
Who would have thought?
Yeah, it's funny that.
What's the alternative?
Well, there are a few alternatives. The ones that we are seeing come out more commonly are, of course, workers' compensation. Now, that is, of course, only possible where the bullying takes an extreme form that results in an actual injury to the employee. So if an employee, workers' compensation, if a worker is bullied so severely that they develop a psychiatric injury, which is the more common one, or less common, but more easily provable, a physical injury, if bullying takes on a physical form, then they can claim workers' compensation for that. And quite interestingly, there are recent cases coming out of workers' compensation tribunals where the person's involvement in the business or the enterprise has been almost entirely reliant on the fact that they are going to be the victim of systematic bullying. Yeah,
absolutely. So we saw a case very recently that involved a reality TV contestant. And essentially everyone knows them. They were the villain. They were the villain on that show. They were painted to be the villain. And what came out from... and they essentially went to the regulator and said, as a result of the network's conduct, it's had profound implications on my personal life, getting threats, that kind of conduct, and suffered a psychiatric injury as a result. What came out of that case is we got some really interesting context about what happens behind the scenes and what it goes into creating a villain on a network TV show. Like, did you read? Apparently, they would just show the negative comments this person made about other contestants. So they would do the talking heads and just show it to other contestants, which I thought was only one way to do it.
It was one way to do it. I mean, I was watching at home. I think we have a fairly cynical view of what goes into these reality TV shows.
Yeah.
And we expect that pretty much everyone is acting. But it seems in this case, the non-villains, as it were not acting. Their reactions were genuine, but they were reacting to a false pretense.
Yeah. So then it works essentially created a character where none existed, and as I said, as a result of that, this particular individual who wasn't an employee, which is we'll return to that distinction, suffered psychiatric injury and ended up obtaining workers' compensation against the network's insurer. Now, does it matter that they weren't an employee?
Well, absolutely not. Even under the Fair Work Commission, it's called Stop Bullying Order, and you only need to be a worker to enliven the jurisdiction.
So what's the difference between a worker and an employee?
Well, a worker can include anyone, well, it includes employees, obviously, but it includes anyone who is in some kind of contract of service or for services with the employer or the principal. So it includes contractors, and it includes contestants on reality TV shows in certain circumstances. Volunteers as well. Yeah. Volunteers can have a right to not be bullied when they're engaging in their volunteer work, and so on and so forth. Shout out to all you interns at various firms at the end of the university year. Keep that in mind.
And I think that's really a unique feature of bullying in general, that you don't need that employment relationship to be protected from it. All you have to do is be a worker within its various definitions, which kind of brings us to the third. So we've got the Fair Work Commission. Fair Work Commission can't make any orders with respect to compensation. You have to be an employee, you have to still be a worker, so your engagement as a worker couldn't have ended. And all the Commission can do is say, we'll issue an order that the bullying is to stop. Workers' compensation, again, all you have to do is be a worker, and you can file a claim against the principal's insurer. And there is, of course, monetary consequences flowing from doing that. And the third is probably the most direct form of compensation, and that is safety law. What happened in 2019 was what is believed to be the first successful prosecution of bullying under WHS laws. And it was for an electrical company in South Australia. Granted, it was probably on the extreme end of the spectrum. Essentially, there was an apprentice who was doused with lighter fluid and set on fire. Fortunately, he was unharmed.
Miraculously.
Yes, miraculously. Reportedly, it was a sort of practical joke. That case was believed to be the first prosecution of bullying under safety law. And flowing from that was pecuniary penalties. So there were fines imposed in that place, in that case. So if anything, and again, very, very extreme example compared to bullying in the Commission, which might be anything from not being invited to after work drinks to having rumours, not to undermine or minimise the impact of those things, but there's a much lower threshold to get into the Commission.
And there is also a fourth area that I would like to touch on.
A fourth area? I hadn't prepared for this.
Well, that's because you haven't worked on the employee side, my good friend. But there is a fourth area. Certainly, the Work Health and Safety Regulator can prosecute to get penalties. Those penalties are paid to the state, not to the victim.
That's right.
If the victim, however, wants to take their own avenue of recourse, if the reason for the bullying, or the apparent reason for the bullying, is a protected attribute under anti-discrimination law.
So,
bullying that's based on homophobia, for example.
Right.
The employee can take their bullies and their employer, or the principal, whoever, to the Anti-Discrimination Commission in the relevant state, territory, or indeed to the Commonwealth level.
But that very much depends on the type of bullying.
It does depend on the type of bullying
and
generally.
It's almost unhelpful to kind of group all of these different behaviours into bullying. But I think what it does demonstrate is that bullying behaviour is no longer, it's just subject to the scrutiny of the Commission, where the stakes are, quite frankly, quite low. You've now got anti-discrimination, you've now got workers' compensation, you've now got safety. And all these things need to factor in, particularly to employers' decision-making, to be managing those risks in the workplace. What's your takeaway? One takeaway. Give me a takeaway, Alex.
Well, I'm screwed.
Yeah, you are, mate. Well, that concludes this episode of Legal Beagles. Thanks for joining us. We're excited to see, well, excited perhaps isn't the right word, but we take a keen academic interest in seeing how this is going to develop moving forward and whether we're going to see more prosecutions, particularly under safety law. So join us for the next episode in a few weeks' time.
Good luck.